Picture this. You spent the last 2 years grinding away, working tirelessly to perfect your video game, and it's finally all come together. You have the artwork, the dialogue, the music, the source code, and many other creative assets to make up your end product. It's everything you've dreamt of. But now you start to worry. With all these high quality assets, from professional music production to stunning cinematography, what is stopping someone from using your assets to create their own game? Essentially, stealing your hard work. Luckily for you, your answer lies in your copyright. This is Amar, founder of Amar-VR Law, a law firm in Ontario specializing in video game law. I help developers and gamers make a legitimate career in the video game industry. Today, we'll go over what you need to know about copyrights in Canada and how they apply to you in the video game industry. Let's dive in. You might already have an idea of how copyrights work, but if this is the first video game you've created, you'll need to know how copyrights affect video games differently. So let's go over the basics. At its core, a copyright gives you, the copyright holder, the right to produce, reproduce, or publish your game, or any substantial element of your game. If someone or some company reproduces your game or a major asset of your game without your consent, they're stealing your copyright. This is called copyright infringement, and you can take legal action when this happens. When it comes to your video game, your copyright protects your artistic, literary, or creative work. This includes just about every asset of your game, like your source code, your artwork, design, and animation, the music, the dialogue, scripts, and more. The Copyright Act of Canada prevents individuals from getting around protective measures that you have in place to restrict access to your creative assets, and protects you from the unauthorized streaming or sharing of your game, such as streaming the gameplay online. As the creator of your game, or the author of the work, you hold the original copyright. It's important to note that anyone who contributed to a component of your game might have a claim to copyrights for any asset that they helped create. For example, a freelance designer or a studio who created the artwork for your game may hold the copyright to the artwork, but not the whole game. Alternatively, your employee who creates a component of your game is not a copyright holder. At the end of the day, copyrights are your top defense when it comes to protecting your hard work. So it's important for you, as a game developer, to know how they work. Your copyright is one of the first IP protections you need to consider when making a video game. The great thing about your copyright in Canada is that as long as the Copyright Act's criteria are met, you're granted an automatic copyright as soon as the work has been created. There are certainly benefits to registration, especially in a contentious claim, but you are protected at a basic level without doing so. There are 3 criteria your game needs to meet to be protected by copyrights. 1, your game must be a work of authorship. 2, it must be original. And 3, it must be fixed in a tangible medium of expression. So, criteria 1, what is a work of authorship? Any product of creative expression, such as literary work, music, drawings, computer programs, or a similar creation, published or unpublished, is a work of authorship. Since your video game is a product of creative expression, it meets criteria 1. Criteria 2, your work must be original. This means your game must not be a complete copy of an earlier work, and must have at least a small yet significant amount of creativity involved. So as long as you created your own game rather than copied one, you satisfy criteria 2. And criteria 3, the work must be fixed in a tangible medium of expression. This means that a version of the work must be recorded or documented in some permanent form that can be viewed, communicated, or reproduced. It can't just be an idea in your head. It has to have a tangible and reproducible form. Since your game will be interactive, it meets criteria 3. If your game has met all of these criteria, then you already have the basic copyright. This alone may be enough to protect your intellectual property, but it's a good practice to register your copyrights to give you that added protection and best defend your artistic rights in the case of copyright infringement. or if someone makes the same claim against you. Why should you register copyright? It gives you a head start when it comes to proving you're the owner of a creative work if you end up in a legal dispute. And though it won't guarantee that courts will rule in your favor in a lawsuit, it does strengthen your case, since your copyright will be officially registered with the government. If you're not familiar with the legalities of the video game industry, I suggest working with a lawyer experienced in copyright law to avoid potential issues before they even arise. It can be inexpensive if done right and save you a fortune in the long run. Though you are able to register your copyrights without the help of an expert, it's highly recommended you consult a legal professional about your copyrights and those of any staff, freelancers, or other people who contributed to your video game to avoid the risk of legal action and make sure you own all the rights to your video game. Working with a lawyer is a great way to be proactive about your copyrights and to protect yourself and your intellectual property rights. Law firms that deal specifically with the video game industry and the game development process know where the common points of contention are and can help you to create agreements and documentation that clearly outline the copyright of any contributor before an issue comes up. A lawyer can help you navigate the tricky legal environment by crafting agreements that satisfy your freelancers while giving you ownership to your assets. This helps to mitigate the future risk of legal action against you or your company. For example, you could potentially face a claim from a freelance composer you found online who believes they hold a copyright to the music they created for your video games. Working with a lawyer will also help you to avoid infringing on the copyrights of others while developing your video game. If their expertise lies in intellectual property, they can help you avoid infringing copyrights by determining what is restricted and what is available to use in your game. Overall, the money you save by handling your own copyrights probably won't be worthwhile if you end up in court due to an oversight or misunderstanding of copyright law that could have been easily avoided with some legal guidance. I hope this has helped you to better understand your copyrights as a video game creator and how you can protect yourself and your game from bad actors who want to use your work without your permission. That's all for our overview of copyrights in the video game industry. Thank you so much for watching. If you enjoyed this video, be sure to like and subscribe to our channel. We have lots of great advice coming up to help video game developers, streamers, and professional gamers navigate their unique legal environment. Again, this is Amar Sidhu of Amar-VR Law. I'll see you next time.